So what we thought we'd do is, there's actually an order to this. What we thought we'd do is say, first of all, let's put the legal context in front of you so you understand, what the kinds of legal issues are that we need to deal with. Then we're going to be dealing with the technical issues. Dave's going to be talking about that. There's the development-related issues that Mitch will deal with. And then, of course, we have the issues around the finance. So first, let's talk about the legal issues. And why is it that people are so concerned about contaminated sites? Well, it has to do with the liability associated with those sites. And so what we're going to do is we're going to very briefly talk about those three kinds of liability. So there's common law liability, and I'll explain what that is. There's contractual liability. So once again, I'll explain that. And last of all, there's the kind of liability that most people think of, and that is the liability under Ontario's Environmental Protection Act for the contamination that may be present under or on the property. So first, let's talk about civil liability. So civil liability is where people like to sue each other. You have a contaminated site, there's migration of contaminants off the site, the person who is being impacted by that will sue. And so what we have is, that off-site liability. People are concerned that they're always going to be exposed to lawsuits for that kind of off-site migration. There's also on-site liability, and that is where you have some high degree of contamination on site that may give rise to some concern on the part of a resident, that may give rise to a claim by that resident. So you happen to buy a piece of property that you think is a residence. It was located on a former oil refinery. The remediation was conducted in the 60s, and then you discover that it is still contaminated. So of course you're going to be concerned, and so there's the liability that attaches then to that kind of situation. What we're concerned about when you're doing a brownfield development is minimizing that liability. So first of all, you need to understand what that liability is, and then second, how it is that you can go about minimizing that liability. So let's take this first instance of, and in some senses the law helps us here because there have been some recent changes in the law. So the old rule used to be you had, let's say it was a gas station. There's migration off-site. It's impacting on the adjacent property owner. The adjacent property owner sues, and under this previous case, Tridan versus Shell, the previous that off-site property owner was entitled to the return of their property to a pristine condition. If it wasn't to a pristine condition, then they were entitled to stigma damages. You could clean it up to meet the Ministry of the Environment standards, but there's still contamination, so accordingly the rule was there's stigma. So if you had the gas station, if you were the owner of the gas station, you're going to be concerned about that. That's a lot of liability to carry. The new rule really flows from a case that involves the nickel refinery in Port Colborne, and in that case, there's air emissions from that refinery that went on for a period of about 50 years. There's nickel in the backyards or on the properties of a number of people. There's a Ministry of the Environment standard that applies to nickel on land. And so those homeowners sue. They say, Inco, you have caused damage to my property. And it's interesting because if this previous case applied, you'd think they would be entitled to the return of their property to a pristine condition. Not true. The Ministry of the Environment says, yes, there is a standard that applies to nickel, but it applies to plants. A health-based standard is much higher. Out of all the properties in Port Colborne, only 25 of them exceeded that health-based standard. The one person who didn't allow their property to be remediated sued, and she lost. Even though there is contamination on her property, even though the contamination exceeds the Ministry of the Environment standards, so she lost. And so what's interesting is that as a result of this recent case, we're now kind of looking at this whole issue of off-site liability and asking ourselves, is that such a big liability anymore? How do you address that? You need to minimize it, but it's important to understand that it's not as big a liability as it used to be. So we're all beginning to get a better sense now of what that is. Also, somebody says, my property's been impacted. You contaminated my property. It's not enough to say it exceeds the standards. The real question is, and you have actually a couple of properties here in Brantford where this is the case, the real question is, has the presence of that contamination impacted the value of that property at all? So you have a number of instances where there's a solvent in the groundwater, trichloroethylene, and then there's been no demonstrable impact on property values as a result of that. So if you're the owner of the contaminated site, you're going to take some comfort from that. If you're the person wanting to develop that site, you're going to take comfort from the fact you're not going to be then responsible for returning those properties necessarily to a pristine condition. The other type of liability, I'll deal with contractual liability last, is under the Environmental Protection Act in Ontario, a cleanup order can be issued to anybody who owned or occupied a property. So you're a tenant, you occupy a piece of contaminated property, it's contaminated, the ministry can issue an order to you as the tenant, even though you didn't cause the contamination. If there's off-site migration or risk to human health and safety, an order can issue to you, the tenant, even though you didn't cause the problem. Similarly to owners and former owners. So you buy a piece of property, you don't do the necessary investigations, there's off-site migration of contamination. You didn't cause it, but an order can issue to you to clean it up. So you need to be aware of that. And when I say in the course of doing these kinds of brownfield remediations and redevelopments, you need to be able to understand, the extent of that liability and then how to minimize it. So let's then talk about the contractual liability, because that's where this fits in. So I have a gas station. It leaks. There's gasoline floating on the groundwater. I have a purchaser, and the purchaser is interested in buying the gas station and putting up a high-rise condo. And the purchaser is saying, well, wait a minute, there's gasoline, it's migrating off-site. The purchaser is saying, there's contamination on-site. The purchaser is saying, how do I minimize that liability? Well, what the purchaser can do, and you can enter into an agreement whereby the current owner says, okay, you can either take it as is where is, so I'll sell it to you at a reduced price, but you, the purchaser, take on all that liability. Or we could do it the other way. I'm going to sell it to you for full market value, but you take on as the purchaser all of that liability. And there's a whole bunch of things in between. So for example, I could say, yes, I'm the gas station owner. You know what? I'll be responsible for the off-site contamination, the stuff that's migrating off-site, but you, the purchaser, have to clean up the on-site. And so there'll be a requirement that the purchaser do that. So when you're buying a piece of property, what you have is the ability to negotiate the transfer of those liabilities to somebody else. You can negotiate an indemnity, which then allows you to claim against the other person in the event there's a claim against you. So there's the ability under those contracts to transfer that liability. And if you have a knowledgeable purchaser, then in fact you can do a pretty good deal. And there's all sorts of deals that have been done exactly like that. And I'll take that example of the gas station with the floating gasoline. That is the property. It's subject to an agreement of purchase and sale, and they're going to go ahead with a high-rise condo. They're paying full value, and then the seller is going to pay for the remediation. We're going to do some interesting things. We're going to do a horizontal severance. So the seller stays responsible for everything from 30 feet down. We're going to put in underground parking. We stay responsible for everything from 30 feet up. So there's all sorts of stuff that you can do in those contracts that allows you to distribute that liability, and it allows you to do it in a way that you can go ahead with a deal and you can limit your liability and you can make money. So, I'll take that example of the high-rise condo. So what that tells us is then what kind of legal advice do you need? You need the advice on that agreement of purchase and sale, but it's not just the lawyers. Very clearly you need the expertise of the kind of people at the front of the room here. You need an environmental consultant, somebody who is able to characterize the property, somebody who's able to tell you what's there, and who's able to assist you in identifying what is it going to cost to clean up. Somebody who's creative, somebody who understands the rules, and somebody who is a qualified person. So, for example, Dave is a qualified person. What that means in Ontario is that the person can sign a record of site condition, which is the document that gets filed upon completion of remediation. So you want somebody who's a qualified person. You'll also need a land use planner. So for the example I used of the high-rise, we're going to do a horizontal severance. So, that's going to require a land use planner. For the purpose of the development, we need somebody to assist in the design and in assisting in getting all of the municipal approvals. So that person becomes a key part of that development team. And then, of course, there's the lawyer. I should add, the banks play such an important role in this because clearly you're not going to go ahead and do it unless you get financing. So you need to ensure that you also have the support from your lending institution. So when do you get all these people involved? Well, clearly if you've got a piece of property or if you're buying or selling. And then more importantly, it's also during that remediation. So you may have, for example, a lawyer involved in the initial agreement of purchase and sale. But you also want to be sure, to the extent that your agreement provides for obligations for the seller or the buyer, that the lawyer is involved throughout that process in enforcing those obligations. So it's important to make sure that that person keeps involved. So what are the kind of things that we need to consider and what the other speakers are going to talk about? When we're talking about the whole idea of remediation, we're concerned about the uncertainty. We're concerned about the fact you don't know what the liability is, you don't know how much it's going to cost, you don't know if it's going to affect your proposed development. So these are the kinds of things that you need to be able to address. What's the extent of liability? You need to know, for example, if you buy a piece of property that has been causing contamination onto the adjacent property, your civil liability, unless you decide to take something on under the agreement of purchase and sale, your civil liability is only for that contamination that migrates from the date you acquire the property. So somebody can sue you, but what are they going to get? They're going to get a couple of dollars for a couple of molecules of gasoline that may have migrated from the site. Primary liability rests with the previous owner or the person who caused the problem. So you need to be able to understand that. Similarly, you need to understand your exposure to that statutory liability, because those are the kinds of things that are critical. The cost, and this is where you need some degree of creativity in terms of how are you going to remediate the property? You're not going to dig it down to bedrock. It's unusual for people to be able to afford to do that. If you're going to do a risk assessment, then what does that mean in terms of your future use of the property? Once again, those are the kinds of things that the qualified person can assist you with. You need to know about the length of time. You decide you're going to buy a piece of property because the market is just ripe for high-rise condos. If you do a risk assessment, it may take you up to 3 years. Is the market going to be ripe for high-rise condos in 3 years? You need to be able to consider that in the course of doing your planning on the redevelopment of a property. And then the last thing is this protection from liability. So what's in your agreement? And then the other thing is this transfer of liability. There is insurance available. So there's a number of brokers who are very experienced in different kinds of environmental insurance. In the old days, the insurance that you would get was primarily limited to unknowns. So you spent a lot of money characterizing the property. The insurance said, if you find anything else, we'll cover you. Well, that's not worth very much. Since then, there's more availability in terms of insurance. You think your remediation is going to cost you $1 million. There's always the risk that it's going to cost you more. Well, you can buy cost cap insurance that limits your risk to those exceedances over and above your anticipated remediation cost. So there's things that you can do to limit the extent of your liability. And then, of course, last, there's the role of Brownfields incentives. So you know those are present here in Brantford. Those are present in a number of municipalities. And I won't say that is the ultimate, it's not necessarily what makes you decide you're going to go ahead with the development, but what it does, it provides the financial assistance to go ahead with that development. I don't know anybody who's going to decide to remediate the property simply based on municipal brownfield incentives, but what they are going to do is look at those and say, I am going to be able to recover some of my costs, and that becomes an important factor. So those are the kinds of things that you're going to hear from the other members of the panel. I thought, I'd kind of provide that overview, and with that, Dave Flynn.
All right.